Case number 20 CR 220. Dave Ohio versus Allen W. Shoemaker. Present on behalf of the state's assistant prosecutor attorney King. On behalf of the president. Are you Allen W. Shoemaker?
Yes, sir.
Shoemaker is charged with violating a protection order for consent agreement, a third-degree felony, set for trial on April 29. Set for on a pre-trial day, and I have been presented, Mr. Shoemaker, with a proposed plea of guilty form, which indicates that you're going to withdraw your not guilty plea, plead guilty to the charge.
If I may, I believe it's a 5th degree felony.
It is. It's mislabeled in the face of the indictment.
A motion to amend the indictment was filed at some point.
I think that is correct. I recall that actually. Try to check.
Trying to find it.
Yeah, it was on October 30th. I'm going to go ahead and put that on now, just so someone else doesn't make the same mistake I just made. All right, so it's 5th degree felony, Mr. Now, this is a 3-page document I'm looking at here. Has your case number and your name, and it says plead guilty on it. And on page 3, there are signature lines. And up near the top of the page, there's a sentence that says, I enter this plea voluntarily, and below that there's a signature line. And it appears it looks like Allen W. Shoemaker. Is that your signature?
Yes, sir.
All right. When did you sign this document, Mr. Shoemaker?
Yes, sir.
Okay. Out of jail?
Yes, sir.
Okay. And Mr. Armor Travis ever signed it?
Yes, sir.
He went over it with you and explained it to you fully?
Yes, sir.
When you signed the document, did you understand it's an agreement to plead guilty, which means there won't be a trial, the next step in your case will be a sentencing hearing?
Yes, sir.
And you had enough time to fully consider this matter before making this decision?
Yeah, I believe so.
If I may, Butch advised us, everybody knows that we had a chance to spend quite a fair amount of time together yesterday. And Butch has actually had the plea form for probably a month, I would guess. I mailed that to him, so he said,
Okay. Are you entering in this agreement to plead guilty voluntarily?
Yes.
Right now, Mr. Shoemaker, the agreement states on page 1 that you're going to withdraw your not guilty plea guilty to the charge of violating a protection order consent agreement under 2919.27A1 of the revised code of 5th degree felony. Further states that you understand that the maximum penalty for that could be 12 months in prison. And a fine of up to $2,500. You understand that? And since you are already serving a prison term case in this court, any sentence that would be imposed could be ordered to be served consecutively to the sentence you're already served. You understand that? You speak up. You speak up because we're recording.
I didn't hear what you said.
I'm sorry. If you are sentenced to prison on this offense, that sentence would be ordered to be served consecutively, meaning after added on to the sentences you're already served. You understand that?
Yes, sir.
Okay. Now, other than the sentences that you're currently serving, in this case, are you facing any felony charges in any other jurisdiction?
No.
And you're not currently on parole, probation, community control, or post-release control?
No.
Right now, under the law, if you are sentenced to prison for this offense, once you serve the sentence imposed by the court, the adult parole authority could, at their option, place you under what's called post-release control supervision for a period of up to 3 years. They don't have to, but they could, but it's up to them. And if they do, you'll be supervised by a parole officer on the terms they set. And if they decide that you have failed to comply, then they can return you to prison, make you serve an additional period of up to half, whatever prison term was imposed for one more violation. But if you violate or if you commit a new felony while on post-release control, then in addition to whatever sentence the judge in the new case would impose upon you, that judge can also authorize the sentence in this case to an additional period of 1 year, or whatever time that on that period of post-release control territory is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
All right, now, This is not a mandatory prison sentence offense, so under the law, it is possible that instead of getting a prison sentence, you could be given continued control or probation, meaning you be supervised by a probation officer in a term set by the court for up to 5 years. If during that period of time the probation department felt you were not compliant, they would file a notice of that to the court. You would be given a copy and have a hearing, which would be represented by an attorney. And the outcome of the hearing at that time was you felt compliant, then you can be sentenced to 12 months in prison, fine $2,500. You understand that?
Yes, sir.
All right, now the charge in this case, Mr. Shoemaker alleges that on or about the period June 1, 2020, and continuing through September 15, 2020, in Madison County and as a continued course of criminal conduct in Huntington County, you did recklessly violate a term of protection order or consent agreement approved pursuant to ORC section 2920.26 or section 3113.31 in Huntington County Common Police Court case number 20DD060 on April 21, 2020. Having previously been convicted of violating protection order or consent agreement in Huntington County Common Police Court case number 19 CR 119 on November 6, 2019. That's a violation of section 2919.27A1, the violating the protection order or consent agreement. All right, now, Mr. Shoemaker, do you understand what it is you're alleged to have done in that indictment? What the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand the possible penalty for that offense? Yep. Now, you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you try to raise at trial, and possible outcomes of a trial with your attorney.
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Have any threats been made against you to plead guilty here today?
No, sir.
Now, on page 2, there is a, there's been several lines were printed in bold and underlined, but then there's been, part of that has been marked out, and there's been also an additional change made in ink. So, let me read this to you, as I understand it. State defense will argue sentence. State agrees not to pursue charges against defendant for contacting Teresa Shoemaker between the dates of October 6, 2020 and April 14, 2021. Is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, do you hold any license or certification from any state, agency, or board for any trade, occupation, or profession?
Probably not anymore.
Okay, what kind of license did you have?
I did have a license for Medicare and Medicaid rehab.
Okay, all right. Well, I don't think that's one of the ones we're required to notify, if you will, of them on conviction. But if you still have that license, a conviction could be sent to them, and then they could take action on that if they stop processing the program. You understand that?
Yes.
Yeah. Now, you have a constitutional right to understand before you accept a plea of guilty. First, you have a right to have counsel and armed counsel appointed to represent you. Now, he wasn't appointed simply to work the case out, but provide any kind of defense that might be available to you under the law that you would like to provide. So, if you decide you do not want to plead guilty, he'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes.
Okay, now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be chosen from a group of citizens in this county, summoned for jury duty under your trial. After those 12 people were selected, the evidence would be presented, they'd be instructed on the law by the judge, and then they would decide by unanimous verdict, all 12 have to agree on whether the state proves your guilt. Now, if you did not want to have a jury trial, which you did not want to plead guilty, you could waive, and right, waive means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law. The judge would decide whether or not the state proves your guilt by proving beyond a reasonable doubt. Do you understand that?
Yes, sir.
Okay, now, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions, that's cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Okay, now under the Constitution, you have the right to use the power of the court to compel or force witnesses on the court to testify on your behalf, just like the state. So if you have any witnesses you're not certain are going to appear voluntarily, at your request, the court issues a court order as a subpoena that forces those people to come to court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have the privilege against self-incrimination, which means you're not forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way or any person. No one's even allowed to comment, except for one situation, that is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand? Excuse me, understand that?
Yes, sir.
Right under the Constitution, Mr. Shoemaker, you're presumed innocent of this charge, you're proven guilty by the state of Ohio of every essential element by proof beyond reasonable doubt. What that means is that the burden isn't on you to try to prove you're not guilty. In fact, at a trial, you're not required to present any evidence in defense at all. You may, but you're not required to. Whether you present any defense or not, the burden of proof remains upon the state to prove your guilt, proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right, now, originally, you entered a plea of not guilty, Mr. Shoemaker, and that plea denied the allegation in the indictment, denied you committed any crime, and exercised and invoked all of the rights that I've just described for you. Now, if you change your plea today from not guilty to guilty, the guilty plea is the opposite of not guilty. Guilty plea will admit the allegation in the indictment, admit the crime, and that plea waives or gives up all the rights I have described for you this morning, except the right to have a attorney. You always have a right to have counsel, no matter what you plead, with that exception. A plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up the right to confront witnesses against you and cross-examine for your attorney. It would waive or give up the right to use the power of the court to compel or force witnesses to be in court on your behalf to save the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. And the way to give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you may have had until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you can file an appeal that will have to be filed within 30 days of your sentencing entry being filed. You understand all that?
Yes.
And Mr. Shoemaker, are you a U.S. citizen?
Yes, sir.
All right, do you have any questions about the charge or the possible penalty?
No, sir.
You understand them?
All right, sir. Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yep.
Have any questions about the constitutional rights I'm explaining to you?
No, sir.
You understand those? Do you have any questions about the plea of guilty, what it means, what the consequences of that will be if you enter here today?
Yes, sir.
Well, first of all, do you have any questions?
Yes, sir.
Okay, now do you understand that I got it out of the way?
Yes, sir, I do.
Okay. Is there anything you'd like to speak with Mr. Armentrout about before we go any further?
No, sir.
Do you have any questions about anything that I've explained to you here this morning? All right, then is it your decision to withdraw your not guilty plea or plead guilty to the charge in the indictment, pursuant to the agreement that we just done?
Yes, sir.
All right, then answer the charge which alleges that on or about the period of June 1, 2020, continuing through September 15, 2020, in Madison County and its continuing course of criminal conduct in Highland County, Ohio, you did recklessly violate a term of protection order of consent agreement approved pursuant to ORC 4920.26 of 311331 of the Ohio Revised Code in Highland County Common Police Court case number 20ED060 on April 21, 2020, having previously been convicted of violating protection order of consent agreement in Highland County Common Police Court case number 19CR119 on November 6, 2019, violation of section 2919.27A1 of the Ohio Revised Code, charged with violating a protection order or consent agreement under 2919.27A1 and 5th degree felony, carrying a possible prison term between 6 to 12 months, fine of $2,500. How do you plead?
Guilty, sir.
Okay. All right, the court will find that on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of saying, pursuant to Rule 11, plea is accepted for trial. The defendant is found guilty of the offense. Now, there's not a request for a pre-sentence investigation, and I don't think it would be once Mr. Shoemaker has been before the court in other cases and is serving a prison sentence. So I will go ahead and proceed with sentencing here forthwith. Anything from the state?
Thank you, Your Honor. As the court just indicated, this defendant is currently serving a term of incarceration. He was convicted out of this court back in 2019 in 3 separate cases over 19 CR 64, 19 CR 119, and 19 CR 122. The charges in those 3 cases included breaking and entering, failure to appear, menacing by stalking, and violation of a protection order. The victim in the menacing by stalking and the violation of protection order is the same victim as in the case before the court right now. That would be the defendant's ex-wife, Teresa Shoemaker. I don't know how to put this really other than to say that it seems the defendant has developed an unhealthy obsession for his ex-wife. His current prison term, I think, is set to expire in March of 2023. And I genuinely believe that if he is not incarcerated, he does pose a threat to his ex-wife. So based upon all that, Your Honor, it is the state's request that the defendant be sentenced to a term of incarceration of 9 months, and that sentence be ordered to be served consecutively to the current prison term. Thank you.
Is there a victim impact statement or anything from any representative victim presented to the court?
There is a victim impact statement. 1 second, Your Honor. There should be one. The court doesn't have one.
No, I don't get those until there's a conviction.
Can I approach it?
Sure.
I'll take a look at it.
Yeah, the victim was notified of the proceedings of
Yes, sir.
Marcy's office. It does say here that she wanted to make a statement. This check she asked, but I said this is the mistake. She's not here today. And I'm not submitting anything else in writing.
That's very good.
Sure.
We'd ask the court to, if you impose a sentence, and I know the court's position on this normal, is running concurrently. The court's known Alan Butch, we all know him for years prior to his running into trouble. The conversation I had with Butch yesterday was about 1 million times better than the conversation I had with him a couple, 3 months ago back in the jury room. You know, nobody can give any guarantees. Only Mr. King can stand up here and say he poses a threat if he gets out. Maybe, maybe not, Ron. That's the future, but that's a long time to hang on to an anger. But Butch has had trouble letting go. He did not participate in the divorce proceedings at all by choice. He was married to this woman for, I'm guessing, about 40 years. Is that right, Butch? But in talking with him yesterday, we did more talking than we did about the case. He seems to be in a good place right now. I've got some certificates that I'll use at a later time. He's taking an anger management class and attitude and behavior kind of thing. That if there's any future for him and his wife, and I'm told the problem isn't, she would have to initiate that contact on her own. I think his total sentence is either 33 or 39 months. I don't recall that you imposed earlier. He's not halfway. He's not quite halfway through it, Your Honor. Butch is 63. He was always self-employed. He could be, again, whenever he is released. But I just, you know, he sent the letters. He just admitted to it. He is in prison when he sent them. He didn't pose a direct threat. But clearly, it's a violation of the protection order that was in effect here. So we would ask the court to consider any time it's imposed be run concurrently. Which is this your chance to say anything to the judge if you want to.
Commander, anything you'd like to say? Stand up with.
There's never been any malice or anything against her. The other thing of it is I am Christian, and I believe in God. And the thing of it is, I feel that God has told me that we as Christians, we're all watchmen. And we're supposed to tell each other when we're doing wrong. And that's basically what I've done. I had my youngest son sit there and told me, I talked to him on the phone and stuff, and he kept telling me what she was doing as far as drinking and driving and this, that, and the other. And I told them that they need to get involved because I can't. And they will get involved. So that was more or less, I stepped in. I knew I wasn't doing the right thing, but the thing of it is I was doing what I felt God led me to do. So that's where I stand.
Anything else?
Yes, sir.
Well, Mr. Shoemaker, I'm aware of your involvement in the church, Boy Scouts, and so forth over the years. We were had a lot of interaction before I became judge. And, always worked hard, very talented person in terms of repairing. I don't know if there's anything you could compare effects. Very talented at that. And I don't have any doubt about your sincerity about being a Christian. The problem is that the Bible and our faith governs our religious life, but the law governs the conduct in society. And I can understand why you feel the way you do, but it is not a justification for it. And quite honestly, although what your motives are here, as you feel they are today, it's not always the way it's been manifested. You did things that, tried to break in, and some of the things that you said were extremely intimidating to her. And, and I think one of the issues you have is that, you just don't want to accept the fact that, you're going to be divorced, or you were going to be divorced and now are divorced, whether you believe that that's recognized from God or not, is not relevant to the law in terms of what we must govern ourselves by society. And the other thing that you downplayed, I think it's been inferred or suggested, not inferred, but suggested, and that is that you still have I don't know, obsession is the right word, but certainly an unhealthy focus on your ex-wife. And I know it's hard to let that up. I was divorced 30 years ago, I guess now. When you go through that time, it's emotional and it's difficult, even when it's not, terribly antagonistic, and especially with children. And, feeling that why would that person reject me or decide to move away from me is, something that you just have to come to grips with. And, the older I get, the more I realize that, I can be very difficult. Everybody can be difficult, to live with, and not everybody's compatible with each other, and you have to accept that. And, the other thing you have to realize, and this is something I have to deal with, is you can't control how other people feel about you. And she made it real clear that she's not. And there's your problem. She has made it clear that she's not. And you have to accept that and move on. You don't have to like it, but you just have to accept the fact that it's over. And the best thing for you to do is never, ever talk about her or to anyone else, and certainly not ever try to reach out, because the problem is that with your feelings and your thoughts override your better judgment when it comes to obeying the law. And you display some anger in this, which intimidates her, and is good reason for everyone to fear that you might cause her harm. And that is what everybody's concerned about here. And including her.
I've never harmed anybody in my life.
What's that?
I have never harmed anybody in my life.
I understand that. I'm not saying that.
I've not raised a hand.
But the problem is that when we get into these relationships and breakups, that's when these kind of things happen. There are instances of domestic violence and homicides by people who have never done anything wrong. There have been examples of that even with preachers being murdered by their wives and preachers murdering their wives. So this isn't a matter of, what you've done in the past, it's the emotion that takes over. And that's what I'm concerned about too. I think what everybody's concerned. And so, because it's a continuing pattern of behavior that's violating the law, the court has to take that into consideration. And we believe the court that you need to be incarcerated for an additional period of time for the protection of your ex-wife, and also, I think, protect you from yourself, because it's evident to me that you still have very strong opinions that, you're just trying to do what's right in the eyes of God, and unfortunately, that's not the case. It's illegal, and I don't think that, if divorce is sin in your view of your religion, God forgives sin, and she'd be the one who have to worry about it, not you. You need to be worried about yourself, and that's what you've got to focus on. So, because of this, and also the fact that apparently, according to there were other communications that have not been brought, it's a judgment of the court that you be sentenced to the correctional reception center or to the state penal system for an additional period of 9 months, and that is ordered to be served consecutively to the sentence is already imposed, because this is continuing as a third lighter in prison. Your previous convictions that I just outlined, I think that your conduct shows that criminal offenses show that it's necessary to protect the public, and particularly your ex-wife. Most people think that your ex-wife, not really everyone else. I don't think you're danger to other people, or at least unless they would be identified with your ex-wife. In any event, the court believes that it's necessary to protect that. And this is additional conduct, it's in addition to the other forces of conduct previously introduced to not be appropriate to impose just one sentence for all those, because it would not reflect adequately the seriousness of your offense, and it's certainly not disproportionate since it's a middle range sentence. So that'll be ordered to be served consecutively, and the sheriff says you get 2 additional days, when you were here back in February, on that sentence. Now, upon completion of the sentence, it is possible that the Health Parole Authority may, their option, place you under post-release control for a period of up to 3 years. If they do, you'll be supervised on the terms and conditions they set, and if you fail to comply with those conditions, they can return you to prison, and they'll be served the entire term set by the court for an additional period of up to half of the prison term that's been imposed, which would be 2.5 months. However, if you are convicted of a new felony or under post-release control supervision, and in addition to whatever sentence the judge in a new case imposed upon you, the judge could also sentence you to an additional term of incarceration for violating the post-release control conditions in this case. And that sentence would be 1 year or whatever time that on period of post-release control, whichever is greater. If that occurs, that must be served for the second sentence in the case. You also will pay the court costs, which you have to grant execution order. If you fail to do that, clerk can collect that for direct means, include the levy on bank accounts, waived earnings, and other assets you may have. If that doesn't collect it, then once you complete your prison term, the court authority to do service will give you credit for each hour you work, and an hourly rate set by the court. Each hour you work will reduce your judgment by $5 until paid. All right, is there anything further? There
There you go.
Shoemaker, please don't write any letters to your wife or to anyone else.
I basically turned it all over to God. And it's up to Him.
All right. Thank you.
You guys have a approach to retreat.
Yes,